This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Today's program doesn't have to take a back seat to anybody. It's a program about transaction insurance. The information is for general information purposes only. It doesn't represent the views of Hinshaw, Aon, or any of our representative respective clients. So let's get into this panel. It's an august panel, to say the least. First is Gary Blitz. Gary is the global co-chair or co-CEO of Aon's M&A and Transaction Solutions practice. Aon is the leading insurance broker for transactions insurance of many types. Gary has played an instrumental role in developing transaction insurance. He joined Aon after spending about 20 years as a lawyer for Mitz Levin and DLA Piper. Next is Vip Patel. He's the senior vice president of Aon's Transaction Solutions team. Before his career in investment banking, Vip was a corporate attorney with O'Melveny and Myers and Jones Day. He has an MBA from the University of Chicago and a JD from Columbia. And as his name suggests, he truly is a very important person. Ed Conlon is the managing director in Aon's Litigation Risk and Transaction Solutions groups. He leads the charge on contingent risk litigation, and he assists in developing litigation and contingency risk insurance solutions for policyholders. Prior to joining Aon, Ed was a senior claims analyst at AIG, and he earned his JD from St. John's. Finally, Anthony Dragone, or as he's known in the industry, the Dragon Man, is a senior vice president of Aon's Transaction Solutions team. Anthony handles and oversees transaction liability claims. He counsels clients and advocates for coverage on their behalf. Previously, Anthony was at Hamilton Insurance Group and AIG, and he earned his JD from Penn State. By way of a very brief introduction, transaction insurance, or M&A insurance, as it sometimes is called, encompasses a wide range of coverages. The best known and most common form is representations and warranties insurance, but there's also tax insurance, litigation insurance, both in the form of adverse judgment litigation insurance and judgment preservation insurance. We're going to discuss all of those forms today. There are also some specific contingent coverages for environmental, intellectual property infringement, wage and hours, and other things that we probably won't have a chance to go into. And in view of the size of this august panel, we're not going to burden you with a PowerPoint, but there is an Aon PowerPoint that we can make available to anybody who requested on the registration form. At least for a good part of 2022, M&A activity was down overall, yet the interest in transaction insurance wasn't down, it's been up, and it's being used in a higher percentage of deals. And when you think about it and you think of all the costs involved in corporate acquisitions, the question really is, why wouldn't the parties purchase transaction insurance? And so for the first part of our program, I'm going to turn it over to Gary to fill us in on, and Gary, you have this role because you really are the father of transactions insurance, but why don't you tell us briefly about representations and warranties insurance, how long it's been around, and some of the changes in terms of underwriting and policy content that has really turned it into a popular form of insurance.
Sure. Thanks, Scott. And thanks everyone for having us today. So I got into this business as a young tax lawyer in the early 1980s after law school, where working with Lloyd's of London on tax insurance, where we were insuring investors in leasing transactions that they would get their tax benefits. Something that has applicability today and bigger than ever in the context of the Inflation Reduction Act that went into place last year. For renewables. But that was the beginning of a Lloyd's market that was a really interesting think tank during those years, and would look at opportunities in this space, whether there was one deal to be done or it could be a product. And so much of what we did with them, and I was acting as their counsel, were one-offs. And into the 90s, M&A started becoming a business. The private equity funds took the stage, and people started seeing M&A as something much bigger than an occasional transaction. And we started getting inquiries: could you insure this rep? Could you insure that rep? It might be tax, it might be something to do with the capital structure and the ownership, it might be environmental. And there became a sense that was kind of a silly way to do this, because if you could insure all the reps and warranties at once, you were really changing how a transaction could be structured and allowing a seller ultimately to go home with more money, because they weren't required to leave money behind in an escrow to protect the buyer for breaches of reps and warranties. But the first thing that had to happen was you needed that leap from 1 or 2 reps and warranties to maybe we shouldn't be calling up an insurance saying, here's what we're concerned about, just let's insure the whole package. And so the first time I remember that being done, it had to do with a financial institution that had done an acquisition and was required by the banking regulators to spin off part of the company it acquired. And the buyer of that company, or maybe even their lenders, wanted an indemnity against breaches of reps and warranties. And the buyer, that was now the seller, was saying, well, I'm not giving any indemnity. I've only owned this company for 10 minutes. And it was a complete impasse. And we were able to craft together an insurance package that protected the buyer of the divested company, that they would be protected. And so that was kind of 96, 97. 97, at that point, you kind of had a few insurers doing this. But it was a great idea at that time, not a great product. There were a lot of holes in it. There was interestingly, and Anthony can comment on this, there was a lot of focus when we developed the first policy and started thinking of it as a product on the knowledge exclusion, that we weren't going to insure a buyer for a breach of reps that they knew about. And the way that was originally drafted, it was knowledge, it was constructive knowledge, it was you should have known about it, and not you could have driven a truck through it, not very useful at all. And it really took another 15 years or so, kind of to the 2010, 2011, for the product to evolve and tighten up, and things like the knowledge exclusion to tighten up and get to a point where buyers and their counsel were willing to say, I'm as well off with this insurance policy as I am with an escrow from a seller, and in some ways maybe better off. And that's what it took, and that's when it really took off. And our team in 2013, I think, did 50 reps and warranties policies. In 2021, we did 1,100 in North America. So that was, once it took off, it was really a game changer for M&A. But it took a long time to be trusted, and people want to see claims getting paid. And, we needed the support of the M&A bar.
And also, Gary, it was, more, not just the content of the policy and some of the issues, but it was awkward at first because, part of the purpose of the utility of the product is to help facilitate deals. And at first, underwriters were spending so much time doing their own independent due diligence that it actually slowed down deals. And I think as insurers they staffed up with in-house lawyers that were familiar with M&A and security issues, the underwriting process has been streamlined a great deal.
It took a while for the insurers to learn how to do this. And I remember the first deal we did, it was a US private equity deal. So I'm talking 90s. The diligence fees to the insurers were about $250,000. Compared to today, in today's dollars, it's like 35,000 or 40,000. So it took a long time for the insurers to learn how to piggyback off the work that the buyer was doing and not recreate the wheel. And that was part of what happened over those 15 years.
And Gary, we're going to come back and let Vip really drill down on reps and warranties insurance in a few minutes. But could you spend a few minutes and talk about tax insurance? Because that's an area that you've been particularly involved in creating. But explain to us what it is, what type of tax solution insurance is available, and how it works.
Sure. And contrasting it with rep and warranty insurance is a good way to maybe jump into that. And because rep and warranty insurance also typically includes coverage for a breach of the tax rep. So, and when you think about rep and warranty insurance and what's covered, kind of fundamentally, it's the unknown. It's what a seller hasn't told the buyer, and that's material and causes a loss. When you have a known tax issue, let's say there was a pre-closing reorganization and it's identified as maybe a question mark whether it was done right or there's a high enough comfort level, and it's scheduled in the M&A agreement as a exception to the reps. That's not going to be covered under the rep and warranty policy. It's a known issue. But the tax insurance policy, which will underwrite how well it was done, as opposed to just knowing about it, might be a way to cover it. So what a tax insurance policy would say in that context is, if that pre-closing reorganization is not treated by the IRS as tax-free as expected, and it's successfully challenged by the IRS, the insurers will pay tax, interest, penalties, cost of defending it, and a gross up for tax on the insurance proceeds. So it's a way in an M&A transaction of dealing with a known issue, as opposed to just that there's some unknown tax thing floating out there that wasn't disclosed. But just a footnote, tax insurance also is used well beyond M&A. It can be used without a transaction. So a company has a transfer pricing issue, or they've done an internal reorganization or something not involving anybody else. Companies can use that to add certainty to their tax outcomes. And also a very large part of the work we do with tax insurance is around tax credits, where financial institutions and others invest in deals to get at the tax credits. And that's these days dominated by renewable energy tax credits, although we do it with historic rehabs and affordable housing. But like I mentioned, since the IRA, that part of the world is exploding, and now you can sell a tax credit rather than having to enter into a partnership. So we expect that to become prevalent across the entire economy. But that's kind of the fundamental thing tax insurance does. It takes a known issue and wraps an insurance policy around the tax analysis supporting it.
And, it's not unusual in all forms of insurance that if there's an exclusion in a policy, like in a general liability policy, for environmental claims, let's say, there are environmental coverages available. And so sometimes when things are excluded from a reps and warranties policy, like a tax issue, like a litigation issue, there may be separate products available for that. Before we get into what is going to be one of my favorite subjects with Ed, can you just give us a little bit of info on the size of the transaction insurance market, the number of carriers writing?
Yeah, and it's a little different by product, but it's really a global business today. These products are written around the world, and we have teams around the world. In North America, I'd say there's tax or rep and warranty somewhere between 20 and 25 carriers writing that insurance. Most of them household names that A-rated carriers. Some do it directly, some do it behind an MGU. The lit market is a little tighter, although we just did a policy over $700 million. So there is some depth to that as well. For reps and tax, we can do well over $1 billion per transaction, just depending on the deal and the appetite. Today, it's probably somewhere between $1.25 billion and $1.5 billion, just depending on how you count. And sometimes you need to reach out beyond North America to get these things done. But there's a lot of depth to the market. And just to put meaning to it, a tax policy will be sized based on the tax exposure, but the typical rep and warranty policy, it tends to be 10 to 20% of enterprise value, and with the vast majority being around 10%. So, $1 billion insurance policy is, a $10 to $15 billion deal. So we can really go from the very small to very large transactions.
And as you mentioned, you have to put together, typically for big transactions, a group of insurers. But what are the largest limits? I've seen a lot of policies offering 25, 50, 100 million in limits, but I haven't seen many policies offering more than that.
You mean by single insurer?
Yeah.
Yeah, and guys jump in, but I think, the single insurers don't tend to get beyond 40 or 50. But then you'll see some managed general underwriters who are backed by multiple insurers who can get up to 100, 150. One may even get up to 200 still.
Yeah. So Ed, Vib, I'll give you a chance. We'll drill down on that in a couple minutes, but I'm really anxious to get into Ed's topic, not only because he's got that red power tie on, but because litigation insurance puts together my two of my three favorite words in the world: litigation and insurance. If you can spend a dozen minutes or so filling us in on all we need to know about litigation insurance.
Sure. Thank you, Scott. So in the same vein as tax insurance is known issues, right? Litigation and contingent insurance, similarly, diligence is, for most of the deals, putting aside what I'll call our portfolio type of wrappers, really single case or single risk issues that can be really crystallized. And the level of professionalism has really increased exponentially in our world. We've had over the last several years markets hiring dedicated litigators, with big law backgrounds, in some cases, several of them, and really, focused on this space, right, as non-correlated to the M&A market. But certainly, just to go back to our birth and where the product first started, it was in the M&A context, and it's still certainly very viable and important in that context. And it was essentially, litigation in the way at a target. Difficult to put a number on it, or if they did, the number was just too high for an escrow, and it just would really be, existential to the deal. And so, I know I would say probably 20 years ago, a few of these were being done, right, Gary? And I think more of the more recent vintage started in 2015, right, where we certainly had a deal where we were able to diligence where we thought the most likely damages number would be if our client had gone to trial and was going to lose. There was another theory of liability, which, on the plaintiff's best day, had they been able to be successful on that theory of liability, there would have been, a much higher number, right, that they could have received. So putting all of the diligence and the analysis, and again, all former litigators who spent a lot of time looking at that risk, we determined where that most likely damages amount was. We were able to ensure essentially the delta between the plaintiff's best day in court versus the most likely day in court, above a pretty significant retention. So there was still quite a bit of skin in the game, if you will, for our client. And it enabled the deal to go forward for a much smaller escrow. I would say we continue to see that type of usage of the product with being in the way of an M&A transaction. We're seeing more and more focus on the plaintiff side from the insurers, and I think traditionally we hadn't necessarily thought of that in the M&A construct, but actually one of the more really cool recent usages of the product. We just found a deal recently where it was a portfolio company of a PE firm with quite a large judgment. We were able to insure the judgment preservation insurance initially, as a result of just trying to rehab the balance sheet and being able to pay down some of the unsecured debt, right, decreasing the debt service. And then, that portfolio company was then, nearing its end of the investment, timeline for the PE firm, and they were actually looking to exit. And we were told once we actually placed the insurance that the valuation actually increased exponentially. So we were able to take a contingent asset at that portco that the PE firm was trying to exit, and they were actually able to take the insurance and use it to lock it in to their value. So that was pretty cool, being able to use it on the plaintiff side in the M&A context. It's something I think we're going to see more and more But yeah, I mean, we're our two core products are judgment preservation insurance, and that's exactly what it sounds like. Just, plaintiff side coverage that allows businesses that win significant judgments to lock in some or all their damages pending appeal, right? So it can cover complete reversal or a reduction, right, in the damage award. And then the defense side stuff, we call that average judgment insurance, AJI. Defense side coverage that helps businesses ring fence litigation related risks. You're probably wondering how much does it cost, and does the AGI and JPI cost? And like any good lawyer, my answer is it depends. And so it really is bespoke and tethered to the amount of the risk. We've done deals as low as 4.5% rate online, as high as 20% rate online, and it really is a function of the risk itself. And certainly we have some markets that really want that what I'll call alpha rate of return, where they like stuff with a lot of hair on it, but they feel like they have a really good sense of why it makes sense to do the deal and to structure it. I would say most of the deals probably end up somewhere in the range of, let's call it 8 to 9% to about 12 to 13%, probably in that middle band. And again, rate online is just premium expressed as a percentage of the limits purchased, right? So 10% rate online for 100 million is just 10 million bucks. And then the retention.
I'll just add, it's very dependent on how big a deductible is. So, if someone's looking to insure in that working layer, it's going to be a lot more expensive than if the insurers are kind of taken off the hook and it's looked at as just a catastrophic sleep quiet at night insurance.
Yeah, and the latter is much easier to successfully have done than the former. It's getting harder and harder for the markets to get more comfortable with the former. They used to be a little bit more willing to take flyers on things. Now they, their creativity lies in the other solutions we're doing now. Put it to you that way, where we're doing things like, class action settlement insurance, where we're working with markets where we can help get a buyout for the liability that companies facing in terms of a class action. We can get in there early, either pre or post settlement, to help facilitate a much better outcome, and to ring fence it as well. We're also engaged a lot more in solutions for like long tail liabilities, such as like asbestos, talc, PFAS, which is again for a newer area that we're seeing more and more, and I think becoming more relevant as we're seeing PFAS exclusions in reps policies, right? If I'm not mistaken. So I think ultimately, there's two types of solutions there. One is like an insurance, what I'll call catastrophic cover, cat excess high, excess above, existing insurance, and you will have several reinsurers that are typically ex-US that would be able to work with to put together a syndicate to cover off if you wanted to keep that liability on balance sheet. There is a more non-traditional solution that we work with third-party legacy liability acquirers, right? And so they will spend a lot of time figuring out, what the right number is from an actuarial standpoint, right? If you're trying to forecast the liabilities and the costs for that particular liability, they'll take into account the existing insurance, right? It essentially works in the sense that the entity that has the liability will have to be put on the periphery of the company's org chart, the series of transactions. That essentially becomes the old co. Everything else moves to a new co. And then these third parties, like legacy liability acquirers, they'd have to make sure that there's sufficient capital injected into that old co to take care of the forecast, right? The forecasted liabilities, plus a little bit of a cushion typically. And they will acquire that entity and take it completely off the balance sheet, right? And so it's a going entity. It's got sufficient capitalization. And so the thought process is it's to be sufficient to guard against fraudulent conveyance and successor liability type of claims. There are a few markets out there that are willing to incorporate, not only will they acquire those legacy liability entities from you, but they will also then put an insurance policy on top of that. So almost like double sleep cover, right? To really be sure that you've got, some additional coverage on top of the actual, long tail liability. So asbestos is really you can do both the insurance or, the transactional solution. For anything outside of asbestos, that's mainly going to be only a transactional solution. The insurance markets haven't gotten as comfortable. There's just not as much actuarial data on the other areas.
Ed, are things like schemes of arrangement and what I'll call creative uses of bankruptcy by policyholders, such as what J&J is doing, going back again on the talc claims, how does that impact what you do?
Yeah, it's great to see that. I mean, look, it's a justice system at work, right? And then it looks like that the actual number available is now around like what, 8.9 or 9 billion, whereas they were talking like 1 or 2 billion initially. And ultimately, there is some questions about whether those claimants are really on board or not, and whether that's been somewhat puffered in the press about how many folks are actually going to approve of the settlement. I think ultimately it comes down to a calculus, like it always does in litigation, right? Like it's the time value of money and how that can be balanced against like getting your day in court, right, and being able to actually execute on the much higher number that you could get. So if that calculus ends up more for 75,000 or more of the claimants, in the sense of that they want to go ahead and have their money sooner, I think that works out wonderfully for them. How it works out for us, I think that would, that's probably a lower like valuation number. So I think you'd see more attractive offerings from the markets to cover off those types of liabilities if that actually gets approved and goes forward. So I think that would help open up for more opportunities for either the well, I guess it would have to be the trend for our third-party legacy liability acquirers to have more of an appetite to cover off with this transaction solution there. So
you could have litigation insurance for litigation that results from the transaction, security litigation, shareholder litigation. But as you're pointing out and actually spending a good amount of effort on, it could relate to any litigation risk or litigation problems that are out there, known, unknown, disclosed, undisclosed.
For that solution, yes. Yeah.
What impact are you seeing? You're muted, Gary, but what impact are you seeing at that social inflation is having?
Yeah, I mean, it's on the tip of everyone's tongues. It's obviously a big concern of our insurers as they're seeing, frequency and severity of claims both increasing across the board. I think, it's a tidal wave that keeps coming. It's only more and more capital pouring into the space from, plaintiff side, lit funders. In some respects, it's an equal playing field as you're getting, more funding on the plaintiff side. You're getting better attorneys. A lot of the bigger firms now have began a contingency part of their business, right? So you're getting better quality attorneys than you might otherwise have received. So that's good, right? I think we want to have them at the helm of some of these cases, but it does increase the cost of the premiums, and that's across the board. That's the one lever that the insurers can pull, right? As this wave of litigation continues to come. Some of the markets, some of the insurers have found ways to hedge against that and to actually work with some of the lit funders to find ways to partner up together. I think some of them have said, I can't beat them, I'm just going to join them and find a way to do that. So that's been an interesting dynamic, as well as that's been more along the lines of like portfolio wrappers, for lit funders or contingency fee law firms. Yeah, that's probably I think I've spoken for a little bit longer than my allotted time, so I apologize, but I think that's a pretty good overview over kind of what we do and how the products can add value.
Well, that red tie buys you a couple of minutes. And one quick question that requires a long answer, but if you could give a short one, which is, how does litigation insurance interact with other insurance that policyholders may have, whether it's general liability, D&O, or otherwise?
Yeah, that's a great question, Scott. So, we really focus on trying to look at these risks and finding ways to minimize retentions. So for example, you might have a case where, you can look at different theories of liability, and one is really strong, but one is weak. So if we can essentially point to the weak theory of liability as what would be the appropriate retention, and then ensuring the rest of the case, which is stronger, we've done that. It helps a lot if they're talking defense side now, if there's insurance in place, in existence there, because what will actually happen is we've been able to get the insurers to agree to I think the term is infill their retention. I don't know why they don't call it fill in, but being insurers, we always have to have our different vernacular, right? But infill their retention with the existing insurance, and so they'll allow dollars paid out from the existing insurance policy to fill in the retention, and whatever's left over, they'll have to incur themselves. But it's a really good way to close the gap, right? And if there's existing insurance, I think it's helpful too. You might even have long-term relationships, right, with that client, with insurers on that particular area of liability. It really helps in terms of just delivering on the relationship, then to find better terms for coverage when you can work with those same insurers again on our side.
Thank you. There's so much more we could talk about, but again, the red tie only gives you so much time. Vip, you have done an amazing job, because I know there's been a lot that you've wanted to say. And there's a lot really to be said about reps and warranties, insurance. I'm going to put some specific questions to you on it, and then give you a chance to cover anything that I didn't get to. Obviously, there's two types: buyer side, seller side. Buyer side is the most common type, probably 80% of the market. Let's focus on that, and then we can distinguish and compare and contrast seller side in a moment. But
Sure.
What are the advantages to a buyer in obtaining reps and warranties insurance?
Sure. So, actually, most policies you do place are buyer side policies. That's probably like 98% of our policies are actually buyer side policies, and that's the market overall. It's kind of how the market evolved, was through the buy side process, buy side diligence process. But the historical advantage was always a buyer that was willing to use rep or warranty insurance on a deal had the better bid. They'd be able to win more deals because they're giving the seller a cleaner exit at closing, all else equal. That advantage has dissipated over the past few years as more buyers are willing to use insurance, becoming a more well-adopted product. So it's almost gotten to the point where you kind of have to use it to stay competitive in an auction situation. But aside from that, we view, in our view, is rep and warranty insurance is basically an enhanced indemnity. Underneath the policy, you get typically a longer period of protection than you would from a seller. And as Anthony will talk about on our claims side, there's real tail risk associated with doing M&A deals. A lot of our claims come in 12, 18 months after the deal has closed. And in most instances, a survival period for the general reps underneath an agreement, a deal without insurance, is 12 months, maybe 18 if you can negotiate that. So a lot of claims come in after that period of time. So there's tail risk associated with doing M&A, and this policy does respond to claims for a longer period of time than the seller escrow would. And we can talk about the periods of time in a bit, but that's one clear advantage. Another advantage is you can structure your protection in a more customized way. You're not limited to just 10% protection from a seller in terms of an escrow. You can structure your limits underneath this policies in many different ways. You can structure it to cover certain reps at a higher amount. You can structure it, if you want, to a lower amount, but it's a very flexible product in terms of the amount of insurance you can put on a deal. And on top of just structuring and the duration of protection, it does bring certain advantages to just the negotiation itself. You're not sitting there trying to negotiate reps and warranties. The buyer can extract reps that they want, so long as they can diligence them, they can get coverage for them for the most part. They don't have to negotiate as hard to get reps that they want from the seller, as long as those reps are generally in line with market level reps. And I would say that reps have actually gotten a little bit more buyer friendly with the advent of the product. Those reps can be covered underneath the policy. So it does streamline the negotiation between buyer and seller around the reps and warranties and any sort of indemnity protections. And another benefit, and this is probably more of a private equity benefit, is you're not involving the sellers in a claim situation. So to the extent you're a private equity firm, you're buying a company and you're bringing on the management team to run that company, but there's a breach of a rep claim, the last thing you want to do is disturb that relationship. But you can still want protection for it. Instead of recovering from a seller or a management team, you can recover from an institution that's in the business of paying claims. And that benefit is also just there, whether or not it's a management team you're bringing on to your into the deal. A seller is probably less apt to give up money that that's theirs versus negotiating a claim with an insurance company that's in that business to pay claims. So there's some clear advantages on, outside of just trying to remain competitive in a deal with a buyer with the insurance.
And it also, I mean, it takes some of the pressures off a seller. Maybe its indemnity obligations are less, maybe, the knowledge requirements, and we'll talk about that in a moment, are less. But, one of the key things you brought up is typically you're going to get a 12 to 18 month window from the purchase documents. Most I've ever seen, frankly, is about 3 years, but under policies, you may get a longer period. I've seen 6 years. Is that?
Yeah, so you get 3 years for general reps, and those are probably the most important reps in a deal, generally speaking, and then 6 years for fundamental and tax reps. But many of the reps that are there for 3 years, you can, some carriers, and a lot of carriers are flexible around that. If you're willing to pay additional premium, you can extend those reps out to 6. So we try to do that with certain industries where regulatory type reps are very important. Or
Can
IP
you tell
reps.
us, can you tell us, Vip, a little bit about the type of coverage that's typically provided? Maybe talk a little bit about the definitions of loss and the concept of material scrap.
Sure. So the definition of loss is a pretty standard definition of loss as you would see in a purchase agreement. The difference is there's a general presumption that even losses that are based on a multiplied damage type situation, those are covered by these policies. They're not. It used to be the case that those types of losses were excluded, an outright exclusion when this product was first developed. That's no longer the case. They're silent on the availability of multiplied damages, but and as Anthony would discuss, those claims have been made and those types of claims have been paid. So, for example, a buyer buys a company for 10x EBITDA. They discover a breach that results in a permanent loss of $1 million of EBITDA. That's not a $1 million claim. That's a recurring loss that goes to valuation of the business itself. Those types of claims, you apply a multiple to have been paid. And that's kind of where the catastrophic loss type coverage comes in with these policies is those situations involving whether it's a material customer canceling a contract that results in some sort of breach rep, a financial statement issue that's recurring, multiplied losses or losses based on valuation have been paid. And that's probably where the most severe losses are. And Anthony will talk about that in a minute. And these policies also provide a full materiality scrape. So you're not trying to figure out in a claim whether it's a material, if it's a rep, if a rep's been qualified by materiality, whether the breach was material or whether the loss is material. You're scraping those words out and you're basically getting $1 coverage outside of the retention.
Well, I hope you were proud of me being able to come up with that term. But and Gary had mentioned that typically the limits are 10 to 20% of the enterprise value of the deal. Is that something that's subject to any dispute or negotiation? Are insurers really willing to accept it because we're talking about higher limits being higher premiums?
I mean, most of our buyers or clients insure 10% of enterprise value. That's kind of the standard. Some clients would insure a little, sometimes higher, depending on the deal. They may insure higher for certain reps and warranties like fundamental and tax reps or IP reps or compliance with laws type reps, depending on what's important to that business. But for the most part, 10% is pretty typical. Carriers don't push back on that amount. I mean, if it's a large deal, and you got to place, say, $500 million worth of insurance, you're going to have to stack different carriers and get different carriers involved to create that amount. But there's really little pushback in terms of how much insurance you can put on a deal. I think carriers want to put more premium out there, so they are willing to over-insure on deals above 10, 20% in many instances.
Yeah, but one interesting point about that, it's remarkable how consistent the industry has been with this 10% number, which really just goes back to kind of before the product was there and how stock purchase agreements were negotiated. But I think over time, as we get better data on claims and can overlay what industry policies are written in, there's going to be a lot more thought given to, not by the insurers so much, but by clients as to, do I need more or do I need less?
And, speaking of that, so we can get primary insurance, you can get excess at various layers. When you're talking about the primary layer, retention or an SIR is usually involved. And I think there's maybe less consistency in terms of, what that amount is. I've seen ranges from like 0.75% to 4% of the transaction's value for the retention or the deductible. And what are you seeing and what are you doing?
Yeah, it used to be, pretty much across the board, it was 1% of enterprise value subject to a minimum deductible of say 200 to 300,000. That has come down over the past few years as more markets have entered, there's increased competition. And we've seen retentions, and this is something that we've really seen this year, is given the drop in M&A volume and the increasing capacity out there and the number of carriers, they're really trying to compete to win deals. And one area that they're competing on is the retention. So it used to be the case that deals, to get a below 1% retention, it had to be a deal value of 400 million, 500 million or higher. We're seeing retentions under 1%, 75 basis points for generally speaking, for deals 200 million and under, down to 100 million. So they're really using the retention as a point of differentiation to try to win deals. The lowest retentions now, they're probably in the $100,000 to $150,000 range, down from $200,000 to $300,000. So the economics, even on small deals, where you're saying a deal is under 30 million, where the economics do get skewed because you factor in the minimum retention and the premium, the economics have gotten more favorable for small deals as well.
So in the final couple minutes that we can spend on this, why don't you fill in any blanks that you'd want, including maybe a little bit of an explanation of the due diligence process and what submissions look like.
Sure. So I guess quick process overview. The two steps in the process are, again, the deal quoted and then underwriting. To get the deal quoted, you need some just basic information on the deal. Deal size, certain basic documents, SIM, managed presentation, financials, and a buy-side draft agreement. So that process takes around 2 to 3 business days to turn around. The underwriting process itself is, as Gary mentioned, and as you mentioned earlier, it's no longer a primary diligence process. It's purely a secondary diligence process with some follow-up questions from the carrier based on the underwriting call and the diligence reports that they've reviewed. So the underwriting process doesn't take more than a business week. So it's really a streamlined process. It's not meant to be intrusive into a deal. As long as the diligence is appropriate and thorough, we can get done with underwriting in a week, and in many instances quicker than that if we have to. The carriers are very well versed in being efficient now. Some carriers are more efficient than others, but overall the market overall is pretty efficient at underwriting.
Anthony is last, and I would say not least. Could you just spend a couple minutes with an overview on the claims process and maybe compare and contrast a little bit between a transaction insurance claim and a general liability claim?
Yes, Scott, I'd be happy to, and thanks for having us. And as far as some of the differences between how this policy works and kind of your D&O or your GL policy, typically when you have a D&O or a GL policy, what's the thing that kind of sets off the claim, right? You get some kind of third-party demand, whether it's a civil investigative demand from a government or some kind of consumer class action or some other, third-party litigation, right? You submit that to the carrier. The carrier needs to look at the kind of the 4 corners of that complaint, the 4 corners of the insurance policy. And at that time, it's the carrier's duty to give you a coverage position, usually within some kind of specified time range, right? So it's a relatively straightforward product, though, of course, in a lot of ways, an individual case can be complicated, but that's how your typical GL or D&O kind of policy would work as far as coverage goes. On a rep's case, it's going to be a lot different. The vast majority of the large claims on the rep side are first-party claims. They're not third-party claims. While there are certainly a number of third-party claims that would act a little bit more like the DO or GL situation, your big, large drivers of loss are typically financial statements claims, material contracts claims, condition of assets claims, and breaches of those particular reps. And where this is a lot different is, one, there's a discovery that needs to happen by one of the clients, right? Policyholder has to realize that they have some situation, some fact that they think gives rise to a breach of one of the reps that was given to them as part of the transaction. And once they've identified that, they also need to identify how that breach of the rep is driving some certain loss. And kind of once they have that information, we always tell our clients, come talk to us, and we'll kind of pressure test a lot of this before it goes into the carrier. But the idea at that point is to kind of put a package together for the carrier with a notice submission that says, here are the facts that we have discovered. These are the reps that we think may be breached by these facts. And either here's our loss calculation, or we'll provide our loss calculation once we can figure it out and kind of get the process started that way. And again, where the big difference is between this type of policy and either a GL or a D&O type policy is that the burden of proof to prove that, one, there was a breach, and two, that there was loss flowing from the breach is on the policyholder, as opposed to just being able to submit something for coverage under an insurer. And an insurer is allowed to request information, and until they have sufficient information where that breach has been proven, a coverage position is not owed from the insurance company, because again, the burden to prove up the claim is on the policyholder.
And, I have to say, I've done a couple of these with Aon, and the process has been very professional and somewhat different from a typical adversarial, at least GL claim, because there's been a lot of cooperation. There's been a lot of back and forths in terms of providing information to the insurers. And while this is going on, of course, you're dealing with the other party to the transaction, trying to, verify, whether or not you've got a breach and why was there a breach and what were the damages. Explain that interplay a little bit, because you're dealing with that side, you're dealing with the insurers mechanically. How's that working? And in terms of coverage, how does that work?
Yeah, Scott, it's a really good question. And I want to kind of highlight that first point that you make, because we have worked on a number of claims together, and we do obviously love working with you. And, one of the things that we always tell our clients is that, expect the insurer to get counsel involved. That counsel is going to be incredibly competent, and don't take it as an adversarial development in the case. They're bringing in someone like yourself because they need a little bit more expertise or a little bit more help navigating what is typically a very complex matter, right? It's a complex matter. It's very fact intensive. All of these policies, while some of the policy terms themselves are not completely manuscripted or bespoke, they typically are, but they're also relying completely on attaching the purchase agreement, and every purchase agreement has its own language, right? So when we're talking about, is it a breach of this rep? You can't say, well, I had a financial statements claim yesterday and I've got one today. Those reps could be written completely differently. They could have different terms, different words, different ideas, right? So you have to really have the expertise to dig into this and really look at each individual rep and the actual wording of the policy. So again, we see our job is in order to kind of help the client understand that, get them to package up the information to send it to yourself and your client, right? So that you guys can kind of digest the claim that we're making, understand it, and we can help you answer any other questions that you may have. To kind of your second point as to what's going on the other side of the transaction with the seller, there's two kinds of deals that we typically deal with. One is a limited seller indemnity deal, where the seller's indemnity escrow is either limited to the amount of the retention or 50% of the retention amount, or there's a no seller indemnity deal, which is a clean walk away, and there's no way to go after the seller unless there's a fraud situation. But when we're talking about that first and more common situation of the limited seller indemnity, when we're dealing with the seller on those points, it's very interesting, because at the end of the day, the insurance policy has its own independent right to review the claim and make a determination about, one, if there was a breach, and two, if there was a loss. And whether or not a seller agrees or disagrees about there being a breach, in theory, has no actual impact on how the insurance policy works, right? Because you could have a seller that says, oh yeah, absolutely, this was a breach. Here's your, whatever the amount in escrow is, I'm happy to give it to you. I realize that's an issue, but that doesn't obligate the insurer to also recognize that there's a breach, because as we can all imagine, especially when you're talking about a limited seller indemnity, there are very competing interests. One, the seller might say, hey, this is a relatively small amount of money given the size of this transaction. We don't want to litigate this. This would be a headache. We have our business that we need to focus on. We're happy to kind of give this up. It's clear enough for us we'll give it up. The other situation could be something that we or our clients think is a clear breach, and a seller takes the opposite position. This is my money. I don't want to give it up. I'm going to be a pain in the you know what, and I'm going to make this as difficult as possible for the buyer to extract this escrow. And what we would always say to the insurance company that says, hey, the seller's saying this is not a breach, and go, the whole reason this product exists is so buyers don't have to deal with sellers anymore, because they're huge pains in the you know what, right? So yeah, maybe we're going to negotiate something less than the full escrow release with the seller, because we just don't want to deal with them. We want to be dealing with you. You're the professionals. You're the insurance company. We bought this product, so we don't have to deal with them. So, what I would typically say is, yes, the insurance company is going to want to see all the communications between the buyer and seller to get some kind of understanding of what the seller thinks of the breach. But that issue in and of itself should not be determinative to the coverage under the policy.
And so you may have a claim where, some of the reps and warranties are excluded, so it's not a focus between the parties, the insurer and the policyholder. You may have a claim where, there's a dispute or there's questions as to whether or not there was a breach.
Yeah.
And then you may have situations where, it looks like there was a breach, but what were the damages? And I know from an insurer perspective, a lot of times for situations, we will turn to experts to assess and help us evaluate, maybe a forensic accountant. Do you do that as well in sort of assessing whether there was a breach and what the loss was?
Yeah, Scott, it's another really good point. I mean, we always advise our clients, if they have a complicated financial structure or some kind of claim where they're going to be seeking more than a dollar for dollar loss, whether again, financial statements, material, customer kind of contract situation, we do advise them to hire a financial expert, because especially financial experts that are familiar with the space, because we feel like they more readily understand the kind of information that the insurer is looking for. And if they can kind of put together a package of information for you and your client and your expert in a way that we kind of anticipate that it's kind of the information that you're going to need in order to evaluate the claim, we always see that process go a lot smoother than whenever the client tries to do it themselves or bring in an expert who's not as familiar with the product. So absolutely. And then just going back to the other point that you made that I think is a good one is, the situation I was talking about with the limited seller indemnity is when we're just talking about that, a limited seller indemnity. Sometimes there are very complicated transactions, or there's some kind of risk that everybody is aware could become an issue. And maybe they have some kind of specific indemnity that's set aside on that particular deal. And in that situation, if you have a claim that kind of straddles both a breach and a specific indemnity, how that is handled can be, a complication. We always try to work with the insurance carrier in those types of situations to say, hey, we see that this is both. We're happy to kind of pursue the specific indemnity first, but we want to reserve all of our rights, because either if it's determined that it doesn't fall within the specific indemnity, or it goes to arbitration, the arbitrator says it doesn't fall within the specific indemnity, we still want the right to go after it as a breach of a rep. But let's do the thing that's good for us and good for the insurance company and try to go after that specific indemnity first.
And let me there's so much ground we could cover, but one point I want to make, and then one final question to you. The point is, most of these policies are not defense policies. There's no duty to defend. Some of them provide indemnity for some defense costs or even some prosecution costs. Insurers have the right generally to associate or to direct those because they have subrogation rights. But what are the 2 or 3 most common disputes you've seen with insurance claims?
Yeah, it's a very good question. I think they basically typically come around valuation, mitigation, and duty to cooperate. I would say those are probably the biggest ones. So valuation, as you can imagine, if we've got a large financial statements claim, we think that the loss is $1.5 million to EBITDA, and there's a 10x multiple, and we want $15 million as a result. The insurance company is going to have their own experts take a look at that and see if that's a reasonable valuation. And what I've learned from, my life as a non-accountant is that if you give the same facts to 2 accountants and you put them in 2 different rounds, the chances that they come back with the same answer is basically 0, right? So, we always got to have to kind of work through those issues to make sure that we're looking and thinking about the same kinds of things. And then as far as duty of mitigation and cooperation, like you said, this is not a duty to defend policy. The insurer does not have the right to control the defense or anything else. So sometimes there can be a disagreement about how a claim should be handled. And what we just try to do is make sure that there's an open line of communication so that the insurer understands the decisions that the client is making and why, and making sure that they have enough time to comment so that we don't run into those types of problems. Because sometimes, despite all of our efforts to tell clients to get us involved right from the beginning and keep us apprised of everything, once a month I get that phone call of, hey, I've got this thing, it's going to mediation tomorrow. What do I do with the insurance company, right? And that's when we're kind of in the scramble fire drill mode, and we always try to prevent that from happening as much as possible.
Thanks, Anthony. And what a tremendous panel.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.